Immunity of International Organizations. Today's The Hindu editorial by Professor Prabhash Ranjan is titled Immunity of International Organizations is no free pass. International cooperation among nations often leads to the creation of international organizations such as the United Nations or regional bodies like SARC. These organizations operate under treaties and enjoy certain immunities in the countries where they are based. The key question raised in this article is whether these organizations should be completely immune from the jurisdiction of domestic courts in the host country, or whether this immunity should have limits. Immunity is generally granted under what is known as the functional necessity principle. The idea is that organizations need immunity to perform their duties without interference from national courts. However, this principle is not absolute. What happens if an international organization acts arbitrarily, discriminates against staff, or violates basic human rights? Can it still claim immunity? The editorial draws examples from global judicial practice. In several countries, disputes often arise between employees and the international organizations they work for. Traditionally, national courts have dismissed these cases, respecting the organization's immunity. But recent trends show that courts are increasingly evaluating the human rights impact of such immunity decisions. The turning point is whether the organization offers an alternative and effective remedy for its staff to seek justice. The International Court of Justice had earlier upheld the UN's internal tribunal system to resolve staff disputes. But simply having a theoretical mechanism is not enough. Courts in Italy, Belgium, and France have ruled that unless the alternative dispute settlement process is fair, impartial, and accessible, the organization cannot hide behind immunity. The test is not just availability but adequacy. The editorial explains that if an organization provides arbitration as an alternative, it must ensure that arbitration is genuinely functional. It should define clear procedures, appoint independent arbitrators, and allow oversight by domestic courts where necessary. Without these safeguards, arbitration becomes meaningless and immunity cannot be justified. In essence, the immunity of international organizations should be respected, but it must serve its true purpose, ensuring smooth functioning, not shielding wrongdoing. Immunity cannot become a license for abuse of power or denial of justice. For UPSC aspirants, this topic directly connects with GS Paper 2, International Relations and Global Governance, and GS Paper 4, Ethics and Accountability in Public Institutions. In conclusion, immunity for international organizations should exist, but not at the cost of fairness, justice, and human rights.